Scott Watson has failed to overturn his convictions for murdering Ben Smart and Olivia Hope. For those of you who are holding out, the long-awaited decision on Scott Watson's attempt to clear his name has been released, and it finds that he did not suffer a miscarriage of justice, and that decision from the Court of Appeal also upholds his convictions for murdering Olivia Hope and Ben Smart. He had intended to make an application for leave to apply to the Supreme Court in another attempt to appeal the convictions. Watson's father, Chris Watson, is reported as still reading through the judgment when he was contacted by the New Zealand Herald. He says it was a hatchet job on his son. That was his immediate reaction to that this morning. But the story is the Supreme Court. It's the Supreme Court, isn't it? Yes. No. The Court of Appeal this morning. Last year, the hearing was last year. It was presided over by 3 female judges, in actual fact. The Court of Appeal, Christine French, Patricia Courtney, and Susan Thomas. And the Court of Appeal has just released its decision, 291 pages of it. It determined that Scott Watson's trial was fair and that the convictions must stand. Ultimately, the judgment reads, the Crown presented a compelling circumstantial case to show that only Mr. Watson could have been the lone man. The evidence was carefully presented, challenged and subjected to submission and analysis. It was a fair trial. They also talked about the strands of hair taken from a blanket from Watson's boat, and Watson's team submitted that it was unfair that they were charged and anything could have gone wrong. But that apparently appears to have been upheld as well. The Crown submitted the DNA evidence linking the 2 hairs on the blanket to the girl Hope had become stronger since the trial, as DNA databases had grown over the past 20 years. So, And on the issue of identification, which was something the defence was holding it on, the arguments were also rejected by the Crown. On both those points, on the hair, the DNA sample, and on the so-called misidentification, the Court of Appeal found there was no miscarriage and justice. The decision stated that the only real issue at trial was whether Watson was the lone man on the boat. Mr. Wallace's identification of Mr. Watson from Montage B, remember this one? This is the identification by the the taxi driver, or the boat taxi at 3 o'clock in the morning, or whatever, was described by the defence as so pitifully weak as to be no identification, or it was said to exclude Mr. Watson. Importantly, however, the Court of Appeal have said the Crown identification evidence was expressly not based on the evidence of any single witness. The Crown was aware from depositions that there were significant challenges with Mr. Wallace as a witness, and those challenges, including those that undermine Mr. Wallace's identification of Mr. Watson from Montage B, were well ventilated before the jury. The court also determined that the Crown had not rested its case on the hairs found on the boat, but that evidence was important. The DNA of one of the hairs showed very strong support it had come from Olivia Hope, and the other that it had come from someone related to her. The possibility of lab contamination or secondary transfer was explored at trial, but remained speculative. And the Court of Appeal also said that everybody knew all this. It had all its ventilation in front of a jury, and despite that, a guilty conviction. In our view, they finally finished, and this is important. In our view, this is the Court of Appeal's view, as released this morning, the incriminating value of some of the strands remained very much intact, whereas the incriminating value of other strands was shown to be relatively minimal. However, taken cumulatively, there is no doubt the jury was entitled to treat the strands of circumstantial evidence we have outlined as consistent with, and indeed pointing strongly to, Mr. Watson's guilt. The decision, unanimous, of the Court of Appeal, published this morning. Listen, on that issue of Court of Appeal Scott Watson, it's a 291-page judgment. It'll be put up on the Courts of New Zealand website. I don't know if it's there now. I'm only reading a summary of it. But I can tell you this. 3 Court of Appeal judges, with no particular axe to grind on this particular issue, listened to weeks, if not, I think it was weeks and weeks of evidence where all of the issues were ventilated. Dear Lord, they were hyperventilated. I've got to be honest with you. That ends it for me, that judgment. I'll read the 291 pages at some time. It won't be this week, but it'll be probably over the weekend sometime. But essentially, the Court of Appeal's decision was relating to whether or not, and this was where the defence were going, Scott Watson received a fair trial. Okay. And they obviously concentrated on, 3 or 4 significant areas in which they argued that justice was not served. And what the Court of Appeal have done this morning is categorically state, well, you did get a fair trial. All those issues were properly canvassed in front of a jury and in front of a judge at your trial. And then they went another step further than that. And that's the issue for me this morning. On the basis of the summary judgment, and remember I haven't read all the 291 ones, but on the basis of the summary judgment that I've seen just now, it would seem that it is the view of those 3 Court of Appeal judges that the evidence still strongly suggests in 2025 that Scott Watson did it. Not simply last century, all right? So, or when the trial was held, but today, as of. So, for those who argue Scott Wilson's innocent, you've got a mountain to climb now. Well, let's put it this way. It was Kilimanjaro, or maybe it was Mount Cook before this particular appeal, but after this, well, you may as well go and tramping K2 and Jandals just quietly, because that's the future.